Dale Carpenter, and I'm a constitutional law professor at Southern Methodist University. I have a specialty in the First Amendment, freedom of speech and religion, and also LGBT rights. Texas had had a law forbidding sodomy since roughly 1860. The law forbade sexual conduct in the nature of anal and oral sex. But in 1973, Texas passed this homosexual conduct law, and it limited the application of the law only to same-sex sexual conduct. That was the first time that had happened in history. The very existence of that law was used as a ground to discriminate against gay and lesbian people. Why? The conduct was so closely associated with the status that the one stood in for the other, and the lesson that this law taught to Texans in the late 20th century is that homosexuals were bad, they could be discriminated against, and it was okay to do so. I wrote a book called Flagrant Conduct, The Story of Lawrence versus Texas. It is really about the background of the lawsuit that produced Lawrence versus Texas, because all of these cases have a human dimension that's often lost in the dry pages of a Supreme Court opinion. On September 17th, 1998, you had two men who were actually arrested in their home, and they claimed John Lawrence and Tyrone Garner engaged in some kind of sexual act in violation of the homosexual conduct law. So they go up the levels, ultimately, and they make it to the Supreme Court, and that case was argued in 2003, and then the Supreme Court came down with this decision in which they actually overruled an earlier decision and said the constitutional right to liberty protects people, especially adults, engaged in private consensual sexual activity. That was a major decision from the U.S. Supreme Court. There were still in place in 2003 13 sodomy laws in total throughout the United States. 9 of those 13 laws applied to opposite sex and same-sex couples. 4 of them, like the one in Texas, applied just to same-sex couples. All of those laws were unconstitutional as of that date. The effect was really huge on American law in general because it meant for the first time that gay people could claim some amount of equal citizenship in our society. And so, within a matter of months, actually, the Massachusetts Supreme Court approved for the very first time under a state constitutional provision same-sex marriage. And then after that, you had movement toward civil unions and recognition and marriage throughout the country. You had eventually the end of the don't ask, don't tell policy, the prohibition on gays in the military. All of this is really made possible only because gay people for the first time had been authoritatively declared by the Supreme Court to be entitled to a right to privacy and a right to autonomy in their personal lives. So when the Supreme Court strikes down a law as unconstitutional, that striking down is really kind of poetic license. It doesn't actually result in the law being stricken officially from the law books. So the law is there in place, it's there even today, and it can only be repealed by the state legislature. For those who support sodomy laws and support traditional sexual morality, it has a benefit as a symbolic gesture of traditional values. The message to the public that you shouldn't engage in that conduct, it's better not to do so, and it's immoral. So it's just a symbolic statement, and I think some people value that symbolism. If the U.S. Supreme Court were to reverse Lawrence versus Texas, that old law just lays there like an unused whip, and a prosecutor could potentially pick it up again and use it for enforcement purposes or for other kinds of discriminatory actions. Well, I think we've had an example of what would happen if, for example, in the case of abortion laws. Once Roe versus Wade was overruled by the United States Supreme Court in Dobbs in 2022, the Texas abortion law, it was argued, sprang back to life, even though it had been unconstitutional. The Supreme Court, again, in the Dobbs decision, held that 50 years of precedent could be swept aside and that the abortion right could be overruled. It was never stricken from the books, and so in theory it could be enforced again by prosecutors. The same kind of thing could happen to the state homosexual conduct law.